Welcome and thank you for joining Part 4 of Seyfarth's micro-webinar series, Partnering for Success, a cross-practice series on top legal considerations for government contractors. This installment of the series will focus on protecting IP in government contracts and subcontracts. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE Credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE Credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Jamaica Shaliga. Jamaica, you may begin.
Hello. So I think that we have a slide with our pictures on it, but my name is Jamaica Shaliga. I am a partner at Seyfarth Shaw in the Washington, D.C. office. I'm in the intellectual property department, and here today with me, I will let Zach introduce himself.
Good afternoon, everyone. My name is Zach Jacobson. I'm also an attorney at Seyfarth. I'm an associate in the Government Contracts Practice Group in the Litigation Department here in Washington, D.C. We're going to be talking to you today about, go to the next slide, please. In the little bit of time we have together, we're going to be focusing on three basic questions when it comes to intellectual property consideration in government transactions. The first question, how does the government even acquire the right to use intellectual property? And I will walk through that, which will be basically setting the stage for the later discussions. It will begin with Jamaica answering the second question. What types of intellectual property are going to be impacted in government transactions? And then finally, we'll conclude the discussion by talking about steps and avenues that owners of intellectual property can take in order to protect their intellectual property from the government in a case of unauthorized use or risk of unintended authorized use. So let's go to the next slide, please. So beginning with how, and more importantly, why the government acquires licenses. Next slide. So let's lay some general background here and why we're having this discussion, why it is increasingly important. As this chart from the Brookings Institution demonstrates, ever since the 1980s, there's been a divergence in investment in research and development, where the private sector has aggressively outpaced the public sector in investing in new technologies. We're almost at the point where there's 4 private dollars for every single public dollar that's spent on research and development. And so as a result, the federal government is increasingly finding itself acquiring through contracts or other instruments, deliverables or outcomes that involve components that have intellectual property protections that normally in a commercial transaction would be subject to the normal intellectual property rules that all of us are accustomed to. If you go to and it's important to note, as I say here on the slide, when the federal acquisition regulation came out of the FAR, this was in the 1980s. This was a time when they didn't have this type of concern. And so if anyone, and we don't have time to get into it here, but if anyone is familiar with the history of the rules and regulations surrounding intellectual property and government transactions over the last 30 years, you'll see that there's been a tremendous amount of change. As Congress and federal agencies and in the private industry, folks have tried to grapple with these questions. How can the government participate as a consumer in the marketplace of new technologies that are frequently protected by different types of intellectual property legal regimes? So now that I've talked about the why, let's start talking about the how. Go to the next slide, please. You'll see that these are the common types of, we call them federal funding instruments. And really, that's because, as we'll talk about a little bit later, the government's interest in acquiring licenses to use things generally attaches to the government's funding of either the development or paying outright for a greater license of use. Now, typically, and what we're going to be focusing on today, a lot of these issues come up in contracts, and that's because the government is acquiring a deliverable, be it a service, a good, construction, you name it. They might be buying something, and within those deliverables, you may have things that are coming to the government that are either commercial products or services, or commercial off-the-shelf items, or are something new that's been developed for a government customer, but nevertheless is subject to intellectual property protections. Now, although we'll be talking about contracts, it's important to remember that grants and cooperative agreements, other types of federal funding instruments, will also have some intellectual property concerns. Because again, once the federal government begins investing in an endeavor, be it transferring a thing of value, usually money, to a grant recipient, or partnering with a recipient in a research and development agreement to develop something new, the government is going to have an interest in acquiring a license to use any new technologies that are developed under that agreement. And we've provided some of the regulations here on the slide for you to reference if you come across these issues under any of these types of common agreements. Next slide, please. So let's take a deeper dive for a minute and talk about contracts and the licenses that the government acquires under them. Now, I say license because typically, even if you're developing something new under a government contract as part of a deliverable, the government typically is not seeking ownership of the intellectual property because the government usually doesn't have a need for the intellectual property ownership. But what they are going to be seeking is a license to use whatever protected information or whatever protected data is in that contract deliverable. Now, the scope of that license, as depicted in this chart that was developed by the Government Accountability Office, will usually attach to the level of funding that the federal government has put into the development. So if something is developed completely by federal funds, in this case, let's say there's a contract deliverable for a software solution that doesn't exist, typically the government is going to be expecting to get unrestricted rights to use that software under the performance of the contract. If this is now in the defense setting, you more commonly see something that's called government purpose rights. So it's a level of rights that are a result of mixed funding, where you have some aspects of the new technology that's been developed with private investment and some aspects that have been developed with public investment. Now, government purpose rights is different from unrestricted rights or unlimited rights in the sense that government purpose rights, you have some restrictions under a certain period of time that then will revert into unlimited rights. And so finally, then, or 100% privately developed, you have limited or restricted rights. And that means there's real restrictions on what the government can do. Now, the scope of these levels of rights are going to be defined in the contract. But it's important to remember that the difference between them can be pretty significant because the government, if given unlimited rights, really expects unlimited rights. And if you're something that isn't entitled to unlimited rights, as I'll talk about a little later, you need to assert what level of rights is appropriate. And we'll also talk about how to do that and what considerations factor in. Now, finally, and I'll note here, this sort of tension between level of investment and level of rights reflects the broader tension that has been observed in the industry and government in dealing with these issues over time. I talk about the Section 813 panel. If you're not familiar with these advisory panels, Congress has established a number of them looking at this issue over the years. And here, in its report, the panel noted that there's diametrically opposed perspectives on intellectual property in industry and government. While in industry, we may see intellectual property as a capital asset, something that is a source of revenue and a competitive advantage in the marketplace, the government sees it as fundamentally an anti-competitive legal regime that exists to stifle competition by locking the government, or as they call it, vendor lock, locking the government into using one contractor for all follow-on support work after the initial production. And so this tension, as the government tries to acquire greater and greater licenses over intellectual property, and referencing back to that first chart, as increasingly more intellectual property is being developed exclusively at private expense, you have then on the private side, people trying to protect this from the government. And that sort of sets up these disputes that we're going to talk about. Next slide, please. So what you're going to see when you're looking at, well, what level of rights is the government in this contract? What applies? Where do I look to find out what types of rights are available? What types of licenses? What are we even talking about? And you need to start with the standard clauses. Now, these are the most common standard clauses, but there are others. And what they will do is they'll apply to the different types of deliverable that could fall under one of these categories. Typically in a government contract, you can be dealing with what we call technical data or computer software. And both of these definitions you see here are pretty broad. And it's important to remember that these aren't the only definitions, but these are the most common ones when you're talking about the government's rights to use either the technical data and the computer software. That's where we even get the term data rights, because we're talking about the government's rights to use this data. I'll also point out that it's important to know who you're dealing with. If you're dealing with a civilian agency or you're dealing with a defense agency, you're going to be looking at different clauses and you're going to look at different parts of the regulation. As you see here, the FAR has one general data rights clause that covers all of these different things. while in the Defense Federal Acquisition Regulations Supplement, you actually have lots of separate clauses for separate definitions depending on what you're dealing with. It's also important to look and see, are you dealing with a commercial technical data or a non-commercial technical data? Because there's going to be different rules and procedures that attach to each. And finally, you'll see on this slide that you don't see a commercial computer software clause. Now, in the FAR, there is a placeholder clause for commercial computer software, but generally what the government has been doing is they've been accepting the general terms and conditions that the commercial software vendor provides to the general public with, and a big caveat, with exceptions, because they will not accept terms that are contrary to law or policy. And oftentimes what ends up happening, if they won't accept the commercial license, you end up going into a negotiation into what we call a special licensing agreement. And in a lot of these contexts, those are becoming more common than the standard licenses that you'll see here. But generally, these are the standard contract clauses you should be looking for when you're dealing with the government. Next slide, please. Okay, so we talked about why the government's doing this. We talked about the different vehicles that exist by which the government may do this. And we also talked a little bit about what level of rights applies, where to find those rights, and the licenses that attach to them in the contract clauses. So how does this actually work? And this slide sort of talks about the nesting doll approach, if you will, of these contracts. And it does in the context of the defense contract. So typically what you're going to have in your contract is you're going to have a contract line item for something, and it's going to have a certain amount that's attached to it. And it's going to be referencing something in your statement of work or the actual thing that you're delivering. And that when you align that together, okay, they want me to deliver a drone. They want me to deliver a certain kind of drone that meets all these different dimensions and has all these different capabilities. But what about these other things? Some of this is going to involve extensive technical data. Some of this is asking for schematics. Maybe there's some computer software components. Well, that's when you're going to look into something that's called the Contract Data Requirements List, or the CDRLs. And that is the delivery mechanism under the contract by which you transfer these things, the technical data packages, for example, or computer software. And within that, there's going to be other documents called Data Item Descriptions, or DIDs. Now, these are generally, the standard DIDs are available online, but the point is that they're going to talk about specifically what they mean within the CDRL when they're talking about delivery of X. It's going to talk about the data content, the format, and the government's intended use. And then finally, you look at all these things when you're putting together your proposal, and that's where you make your data rights assertions. And you're going to provide an assertions table where you go line by line through each of the deliverables, identifying each of the components of those deliverables that have potential levels of rights that are less than government rights that are less than unlimited, and that you assert them. And you have to be prepared to stand up to the government if they challenge them, which we'll talk about later. So that in a nutshell is why and how the government acquires these things. And I think now it's time to turn it over to Jamaica to talk about the types of intellectual property rights that could be implicated.
Hello. So now I'm going to talk from the IP perspective, but I'm also going to follow up a little bit about some of the things that Zach said to clarify. So this first slide is colorful because what I wanted to convey to you all is that what we know about IP rights and IP law does not necessarily apply once you get over and cross the barrier into government IP. So in typical IP fashion, we have above the line rights. These are registered rights. These are patents. They're trademarks. They're registered copyrights. There's formalities of how to obtain these rights. There's requirements for maintenance. There's requirements for how to get these rights. And then there's below the line types of IP. Here we have the inventions. So before you go ahead and you file a patent, when you have an inventive concept, when you've gone ahead and reduced something as an invention, you're trying to decide, is it commercially worthwhile to get a patent on it? You have trade secrets, extremely important, for most companies, particularly those that are dealing with the government. So a lot of the defense contractors, these are not things that you publicize. These are things that nobody really should know about other than the company that's selling the product. There's copyright, just how you're using things as soon as it's in a written form. And then there's also trademarks, things that you're using. Now, once you get over to the government, they don't use the same terms. What they really care about are two things, and these are the key rights that the government looks into and decides to take from you as contractors. The first one is subject inventions. That's the term of art, and then data rights, which is something that Zach already touched upon. So let's go to the next slide. So subject inventions. The thing to keep in mind about subject inventions is if something is a subject invention, then the government is going to have rights to it. So we need to know what a subject invention is. A subject invention is any invention that's conceived or first actually reduced to practice in the performance of work under government funding agreement of some kind. So you can see that I made OR really, really, really big on this slide, and that's for a reason. So unlike what we've discussed about how the funding level tends to be proportional to the license that you get, when you're looking at patents, inventions, not even at the patent level, if an invention is conceived under a government contract, for example, then the government will get licensed. Now, if you have done 99% of all the work, 99% of the 99.9% of the conception, all you really need to do is actually have maybe the government equipment to make sure that it works, and kind of the reduction to practice part of it. If you enter that government contract and you reduce it to practice under that government contract, the government gets rights. So we have to be careful, when we're thinking about what inventions might be created or finalized if you're taking money from the government. So if you trigger, the government's understanding of a subject invention, generally what happens? Generally, the contractor can be the owner. There's a process, we'll talk about that, but the contractor owns the patent. That makes sense. They're the ones that conceived it, they're the ones that reduced it to practice. Everything's standard, just like you were in the commercial environment. The government, however, does receive a license. Generally, that is a non-exclusive, non-transferable, irrevocable, royalty-free license. And the license is to practice the invention or have it practiced on the government's behalf. So once you've conceived or reduced to practice an invention, and it's a subject invention, then the government will get a license. They don't have to pay you for the license. They can take it as long as they want. And it gives them the right to practice the invention or hire someone to practice it for themselves, not necessarily you. So there is a limitation. The government normally can't tell the public unless march-in rights occur or are elected by the government. There's a lot of rules about march-in rights that's not within the scope of our conversation here, but it is something to keep in mind. Now, the reason I said generally is because there are different rules. So as a contractor who has a subject invention, the government can take away your ownership rights in certain cases. First of all, when you come up with an invention, you have to disclose the invention to the government. If you do not disclose that you invented, reduced to practice, or conceived of an invention, and it is within the scope of your government contract, the government can take away all of your rights as a contractor. You don't get a license, you don't own it, it's the government. So disclosing an invention and deciding if you have to disclose an invention, if it does fall into a subject invention, is an important concept. Now, the other thing you have to do is, okay, once you disclose it, you're not done. You have to elect title. So you have to do an affirmative action to say, yes, I am going to become the title owner of this, of this patentable invention. If you don't elect title, then government can take title and the contractor will get a non-exclusive license. Next, you have to apply for a patent. You've elected to take title, now you need to patent it. Now here is the interesting part. The typical rules regarding deadlines of when you can, that patent lawyers are familiar with, they don't necessarily apply. So the government does not give you 12 months to file your non-provisional application after you've filed your provisional application. No, the government gives you 10 months. So first you have to disclose, then you have to elect, then you have to follow the rules about when to file for your patent. If you don't do that, you'll get a non-exclusive license and the government will gain title. Also, certain agencies, certain contracts, by default, you will not become the owner of your subject invention. Instead, unfortunately, you'll get a license. Government will be the owner. I put down some source information so you can look that up, and then we can go to the next slide. Next slide. There we go. So the next slide is data rights. So data rights falls into two categories. And one is technical data, and the next is computer software. So technical data, the most important thing about technical data is that it is an amalgamation of copyright and trade secret legal concepts. First, it has to be recorded, any medium, any form. Second, scientific or technical information. This is very, very broad. Manufacturing, process, manuals, specifications, standards, records, reports, identifying characteristics, the documentation of computer software, the databases, anything technical, anything scientific, that is technical data. Exclusions, so data that's incidental, so financial pricing, management information, and those are not rights that the government typically will take in your IP. Computer software, people think of course, software, source code, object code, but computer software in the context of data rights also includes other aspects. So non-code design elements, so the look of things, algorithms, processes, flowcharts, formula, whatever you need to compile the software, to reproduce the software. So if there's anti-pirating information, all of those things are part of computer software. They're part of data rights. And as Zach discussed, the licenses that you get to those rights depends on funding and what you can negotiate with the company, not the company, the government. Next slide. So government rights and technical data. Here, the contractor will retain ownership. The government will get a license. Scope of that license, that depends. Contract language, source of funding, amount of funding, type of data, administrative requirements, and also your negotiating skills. All right, I'm going to turn it back over to Zach for our next topic.
All right, so how do you protect your IP rights from the government? And this is this is an interesting area because, like most things in government contracts, there's a clause for that. So anyone who's familiar with government contracts knows you typically have a disputes clause that will govern how disputes between the government and the contractor will play out through procedures or through appellate rights as well. They also have the various other clauses and different types of disputes that will apply more rules. Well, data rights is no different. Typically, we have something that's called data rights challenges and procedures. And these procedures will be outlined with the civilian agency under the appropriate clause of the FAR, under the defense agency under the appropriate clause of the DFARS. But like we talked about earlier, you have to remember that the DFARS has different clauses for technical data and computer software. Similarly, they have different validation procedures for computer software and technical data. Although these procedures are similar, There may be some differences that you need to be familiar with whenever you find yourself under a data rights challenge. Now, what does that mean? Well, as we talked about at the outset, contractors are supposed to assert restrictions on use of their data to the government at the outset of the contract, or in the event of an inadvertent omission of restrictions, assert them during performance. When that happens, the government does have the right, if it has reasonable grounds, to ask the contractor to show the justification for those restrictions. Now, of course, the government has to, in addition to having reasonable grounds, it also has to make a determination that it would be impractical for them to go out and compete this. So what would happen? Well, essentially, it's like anything else when you're dealing with the government. You receive an official correspondence and you have a deadline to respond. And so here, as we've outlined, this is very calendar driven, like many of these disputes. And so failure to respond within a timely manner to the government's challenge to your assertion can result in a forfeit of your right to exclude the government's use. Now, how will you respond? That involves showing the source of investment, that goes showing the extent that it's privately owned and the protections that apply. And the clause does a great job of laying out the types of evidence that you need. Now, another thing that's important to remember is, like with any other sort of claim with the government, if you fail to convince the contracting officer, you have the option to appeal. You can either go to the Board of Contract Appeals or the Court of Federal Claims. But, and this is very critical, if you intend to go to the court, although you have a year to file, you only have 90 days to alert the contracting officer of your notice to go to the court. And the reason for that is if you fail to file a notice of appeal within 90 days, the government will assume that you accept the contracting officer's determination and they will apply the level of rights they deem appropriate. So in order to preserve your rights in the interim while you seek an appeal, you must notify the government within 90 days. Next slide, please. In the interest of time, I'm going to go through these pretty quickly, but these are some things you have to think about. One, doctrine of segregability. When you're asserting a level of restrictions on the government's ability to use your intellectual property, you have to go down to the lowest practical level. You can't just say an entire deliverable if it's a deliverable made up of multiple components. And for example, within a computer software, the computer software is not just the program, because as Jamaica talked about, there's a lot of different components within that. And once you get down to the lowest segregable level, it could be as low as a module or a function, then you can assert a certain level of rights. And you need to identify which ones are developed at private expense. The second thing we need to think about is markings. What this dispute is about, even though we're thinking about intellectual property and source of investment, it's really the markings on the deliverable, because you're still delivering what you agreed to deliver to the government. But the question is, what level of rights are marked on that delivery? So that means your markings on all of your deliverables are critical, and they have to comport with the acceptable markings that should be provided within the contract. Failure to correctly mark can mean that you lose the challenge regardless of the justification for your assertion. And finally, subcontractors. There's two things we have to think about with subcontractors. Number one, subcontractors have their own concerns about sharing their intellectual property with prime contractors and with other suppliers, which may result in having to negotiate separate agreements to ensure that their intellectual property is protected. Second, the government can directly challenge a data rights assertion of a subcontractor and skip the prime entirely. That can involve the prime contractor essentially being out of the dispute while they resolve this, because the subcontractor is the owner. And that sort of, in a way, makes sense. But it does not create a privity of contract situation. And if we go to the last slide, I'll also note that the CLE code for this presentation is S as in Seyfarth, S as in Seyfarth, 1497. That's SS1497. All right, get away, Jamaica.
All right, so next and finally is the avenues of relief. So the government has to waive sovereign immunity for you to sue it. So there's only certain places that you can sue when you're unhappy with what the government has done to you. For patents and copyrights, that is the U.S. Court of Federal Claims. So in the event that the government or a government contractor, here it just says contractor, but what they're talking about is the government has hired another contractor. If they're infringing a patent or a copyright, you go to the Court of Federal Claims. You cannot go to your local court. You have to come to D.C. With respect to trademarks, however, there is an express waiver of the government's sovereign immunity, and so IP owners can seek injunctive and monetary relief in any federal district court of general jurisdiction. So you don't have to come to Washington, D.C. if the government decides that it wants your trademark. So that's just a little bit of about the avenues of relief. Like everything, there are deadlines, there are caveats, and the government has special rules. So I think the next slide is the thank you slide. It also gives our contact information. Please feel free to give us a call. Well, it doesn't give our number, but you can find it on the internet. But send an email and we will get back